Hello, everyone. We're just going to get everyone in from the waiting room. So thank you for your patience while we do that. Um, while we get settled, if you can make sure that your Zoom display name reflects your actual name and if possible, your town and organization. So I would be, Lindsay Randall, MAPC, but I am from Ipswich and I'm on the Ipswich Historical Commission, so I would also could put that in. So. Okay. While my colleagues continue to let everyone in, I just want to welcome everyone today. I'm Lindsay Randall, and today the Metropolitan Area Planning Council, the Massachusetts Historical Commission, and Preservation Massachusetts are excited to welcome all of you to the Eastern Massachusetts Historical Commission Coalition, the EMHCC, meeting on exploring historic district bylaws, guidelines, and rules. We chose this topic because a recurring tension keeps surfacing in all of our work, and that is commissions are expected to apply older bylaws and guidance alongside newer state laws and local policies. And the path to alignment is often very unclear. And that uncertainty has led to questions about how to read the text, what authority applies, how to document decisions, and more. And so today's session is intended to be a sort of educational overview, not legal advice or perfect solutions. We are going to introduce shared concepts and plain language that you can take back to your commissions and communities. And we will clarify how commission authority works, explain how bylaws, guidelines, rules, and policies relate, and walk through some examples that show procedures and practice and how others have gone about updating guidelines to align with new state laws and community priorities. And all of this is grounded in the history of preservation work in Massachusetts and the country, as well as national standards, including the Secretary of the Interior standards. And we also know onboarding for new commission members and planning staff is often very limited. And so we hope this recording serves as a clear starting point that you can share with colleagues and new members to your commissions. And to put this all in context and practice, we have 4 speakers who will walk us through the history, authority, standards, and local application. So first we have Michael Steinitz, the Deputy State Historic Preservation Officer for the Massachusetts Historical Commission, who will be sharing the history of historic preservation frameworks in Massachusetts. Our next speaker will be Marilyn Fenolosa, an attorney and former member of the Lexington Historic Districts Commission and current member of the Lexington Historical Commission, who has also served on numerous MAPC Historic District Appeal panels. She will be speaking about commission authority and why clear enforceable rules lead to defensible decisions. And then Sarah Scott, our Senior Regional Land Use and Historic Preservation Planner at MAPC, will discuss how commissions can align their work with community goals. And finally, Lindsay Randall, myself, and I'm the Senior Regional Humanities Specialist at MAPC, will be sharing about the Marblehead Sustainable Heritage Project's process of updating guidelines to integrate clean energy while maintaining historic character. During our presentations, if you have any comments or questions, please put them in the chat. And at the end of all 4 presentations, we'll have time for a question and answer. And yes, the meeting and presentations are being recorded and will be posted to the MAPC YouTube page and posted to the EMHCC page on the website. And everyone who registered will receive a follow-up email with the link to the recording. And before I turn it over to Michael, we're going to share a brief poll to get a sense of who's in the room. And so just take a moment to fill out the poll.
Oops.
Okay. Sarah, you want to share the results?
Yeah, it looks like we're at 65% participation.
Oh, okay. So yeah. So most are municipal staff. So we have some historical commission members, some local historic districts at 12%, and then some other people from state government and regional planning agencies. So thank you for sharing that. And then, sorry, my computer screen is scrolling a little bit. And so what's interesting for question number 2 is, does your commission offer training for new members? Over 51%. No, they do not, and everything. That's what we've heard a lot. I am very encouraged by the yes at 28% that some people offer some sort of training for new members. And then, would you attend a free optional training given by national experts? We had 60% that said yes, that you would make it a priority, and 30% that if the time and location were right, that you would attend. So thank you for that, because that is something we are considering looking into more fully as a resource for the region. So again, thank you all for being here. I'm going to turn it over to Michael to kick us off.
Okay. Let me attempt to share my screen. And here, let's see. Okay. Let me get back here. From the beginning. Okay. That showing up okay for everyone?
No, it is not. We don't see anything.
Okay.
No matter how many times we try this.
This is always a challenge for me. All right, let's try this. Oh, okay. Well, I have to actually hit the share button. That would help. All right.
Hey.
And from the beginning. Okay, now we're good.
Perfect.
All right. So again, thanks everybody for being here this morning. And just special call out acknowledgement to all of you who serve on your local boards and commissions, local historic district commissioners, local historical commissions, and the staff who support those commissions, and for, the dedication of your time and effort to historic preservation in Massachusetts. We really appreciate. And I just want to acknowledge the job you all do on a daily, weekly, monthly basis in administering those districts. So today, I'd just like to give a brief overview and some context relative to the more substantive presentations that will follow. And we'll just proceed. Over the past 70 years, more than 100 cities and towns across Massachusetts have created local ordinances or bylaws establishing local historic districts. Local historic districts are the strongest means available to a community to protect the historic and architectural character of its neighborhoods, village centers, or downtowns. They can vary in size from a single property. Somerville has maybe 100 single property historic districts to an entire town like Nantucket. They both protect existing buildings and assure that change when it occurs is compatible with scale, appearance, and character defining features of the district. While local historic districts today exist together with an array of other historic preservation tools and regulations at the local, state, and national levels, they are in fact the foundation of modern historic preservation in Massachusetts. And if there's one takeaway I'd like you to leave with today is local historic districts are the first modern governmental entity established in Massachusetts. It's the strongest and the first. First local historic districts in the United States were established in the South in the 1930s. City of Charleston, South Carolina, created the first such district in 1931 when it designated the Olden Historic District together with a board of architectural review to oversee it. Soon after, the city of New Orleans created similar historic district for the Vieux and the Vieux Carré Commission to preserve the city's French quarters. These local ordinances regulated changes to exterior architectural features visible from public ways by requiring prior approval by a review board or commission, the basic model for subsequent creation of local historic districts nationwide. In Massachusetts, the first such historic districts were established on Beacon Hill in Boston and in Old Town in Syosconset on Nantucket in 1955. Both were the result of multi-year efforts, but catalyzed in response, finally, to specific development events. In Boston, the demolition of an entire block at the lower end of Pinckney Street and the construction there of a modern 6-story apartment complex, and in Nantucket, the proposal for motel construction along the town's Main Street. Both districts were enabled by special acts of the Massachusetts legislature once the Massachusetts Supreme Judicial Court confirmed that a local historic district was in fact constitutional and did not represent the taking of private property rights. In addition, once the legality of local historic districts in Massachusetts was established, a handful of Middlesex County towns also successfully petitioned the legislature to establish districts under their own special acts. Lexington, Concord, Sudbury, and Bedford all sought to protect their historic village centers with their distinctive 18th and 19th century architecture and associations with the American Revolution, about the same time as the Minuteman National Historic Park was created in this area in 1959. In 1960, the legislature passed the Historic Districts Act, Mass General Law, Chapter 40C, general legislation enabling cities and towns to establish local historic districts through a local process without having to petition the legislature for special law. The statute establishes a procedure for proposing a district through the appointment of a study committee, preparing a study report, and a public hearing. It requires a 2/3 vote of city council or town meeting to pass. It sets specific procedures and requirements for the appointment of district commission members, establishes a process requiring certificates of approval for proposed exterior construction, alterations, or demolitions in the district. It allowed an avenue of appeals of decisions. And it affirmed the district commission's power to seek to enforce its authority and set penalties for violations. While a number of local historic districts were subsequently still created under special acts, Chapter 40C has been, as it has been amended over time, remains the legal framework under which the vast majority of local historic districts in Massachusetts operate today, and under which new districts are created. The context for preservation initiatives for creating local districts was very much the mid-century post-war development environment, fueled in part by federal financial incentives for highway construction and urban renewal that were enabling massive transformations of communities with little regard for their historic architectural fabric. For local historic district commissions, the concerns were the prevention of demolition, the regulation of new construction as compatible, and where possible, the oversight of restoration or rehabilitation of existing buildings to undo unsympathetic alterations that had occurred over time. Neither the special acts nor Chapter 40C included specific design guidelines, although subsequent amendments to Chapter 40C made clear that the local district commissions could create such guidelines as appropriate to their districts. But in the 1960s, few models actually existed for such guidelines. I just note here that the first special act, local historic districts, and the passage of the general enabling legislature for local historic districts all happened before the creation of the Massachusetts Historical Commission in 1963, and before, in that same act, the enabling of local cities and towns to create local historical commissions at the municipal level. Local historical commissions were empowered to undertake research, plan, promote, advise other local boards, and acquire property. In other words, have a general town-wide historic preservation role as opposed to the regulation of specific districts by the Historic District Commission. That said, a number of towns with local historic district commissions designated that commission to also function as the local historical commission. And in many municipalities, the local historical commission has since taken on a regulatory role in administering a townwide demolition delay ordinance. All these local and state level legal frameworks in Massachusetts for historic preservation were created before the passage of the National Historic Preservation Act in 1966. That act established the National Register of Historic Places, created state historic preservation offices to administer federal preservation programs at the state level, created a new federal agency, the Advisory Council on Historic Preservation, the first federal agency dedicated entirely to historic preservation, and most importantly, perhaps, required federal agencies to consider the potential effects of their projects on historic properties and sites and to seek input from the public and other stakeholders, including, in fact, local historic district commissions in many cases. Under the National Historic Preservation Act, the Secretary of Interior was also charged with establishing professional standards for the treatment of historic properties. These were first developed by the National Park Service in the 1970s and codified into federal regulations in the early 1990s. While they were specifically developed in relation to guide federal historic preservation programs, they've become a general standard for historic preservation projects and a guidance framework for how to treat historic properties under the 4 different categories of preservation, rehabilitation, restoration, and reconstruction. More recently, the Park Service has also developed specific rehabilitation guidelines for sustainability and flood adaptation, the first useful in thinking about the introduction of new technologies to local historic districts, and the second for options that may become necessary in dealing with climate change. So finally, I just go back to the purpose statement as amended to the Historic District Acts, which does explicitly acknowledge change. The administration of historic districts over the past 70 years has had to intersect with changes in technologies and materials and with other mandates and initiatives that also promote the general public welfare, but that could result in changes to the appearance of the district. Under Chapter 40C, district commissions have the ability to adopt, modify, and evolve design guidelines that address the changing contexts in which they operate, and to ensure that the maintenance and improvement of the district is appropriate, and to encourage design compatible with all districts. So with that, I'll just wrap it up. Quick overview. Those of you who have background in historic preservation, I hope you could bear with me, but those of you with no specific knowledge here, just a quick context for what's to follow.
Thank you, Michael. We really appreciated that. And again, that sort of grounds us for all the future conversations in this webinar and in the future that we may have back at home in our commissions. I'm now going to turn it over to Marilyn. If you want to share your screen, you can come off mute.
Okay. Hello, everyone. Thank you, Michael. You have saved me a lot of words that I was going to also talk about. And speaking of a lot of words, there are going to be a lot of words on these slides because I've tried to give you places to go for further information. But that means that I don't have a lot of room for pictures. In fact, I have no room for pictures. So bear with me. And then 2 other caveats. Yes, I'm a lawyer, but this is not legal advice, please. And also, I'm a commission member, but I have to tell you that I don't represent either commission. I've been on both the Historic Districts and Historical Commission over the years, but I don't represent them either because I don't want to get them in trouble by something I've said. So having said that, let's start. Why do we care about bylaws, regulations, rules, and guidelines? It's because it provides the framework of your commission. It authorizes your establishment. It sets out your authority to take action. It provides a process, and it justifies the actions and protects you against future challenges. And this chart is really hard to see, so I have provided. You'll see it on when you get, if you get the follow-up. But basically, bylaws are the law. They are defensible in legal proceedings, and they set out broad policies and permissions. Regulations are usually also the law, but with a procedural purpose. They can be combined with the bylaws, as happens in section commissions that are established under 40C. But they are more, they get down into the nitty-gritty of how to do what the bylaw has authorized you to do. Rules, similar to regulations, largely procedural, and guidelines are just that. They are internally adopted. They set out finer details regarding what is covered and with specifics, but they are less enforceable than the bylaws or regulations because they are not laws. They are not enacted into your town's code or your city ordinances. They are guidelines that guide what you do as a commission. Just a couple of examples of the difference between bylaws or laws and regulations. I'm going back to the national level. Section 106, which Michael mentioned, is one paragraph in the National Historic Preservation Act of 1966. One paragraph. It authorizes agencies to consider the effects of their undertakings, projects, funding, permitting on National Register properties. That's it. But then you get to the Code of Federal Regulations, which not only defines what an undertaking is, but it sets out procedures for consultations, who can join, when you have to have them, in order to avoid, minimize, and mitigate any kind of adverse effects, which they also define. The CFR comes in multiple subsections, many pages of very, very small print. But that's the difference. The law is setting out the broad powers and purpose. These regulations are telling you how to accomplish that. In Massachusetts, we have a similar statute and regulations. Mass General Laws 27C authorizes review by state agencies for state-funded or permitted projects. But the Massachusetts Code of Regulations goes further, and it provides all of the implementing procedures, and it also has a nifty flow chart at the back, in case you get confused. So where do commissions get their authority? Well, we've already talked about 40C and Special Act, but just a couple nuances here. Lexington is a special act, which means that not only were we authorized by the state legislature at the beginning, but every time we want to change anything, we have to go back to the state legislature and get their approval to amend the state statute. As opposed to the Enabling Act, Mass General Laws 40C, which says any city or town can adopt this and go with it. But if you want to change it, you can change it as long as your changes don't conflict with the language or the purpose of the General Enabling Act. And you do that through locally adopted ordinances or bylaws, which ultimately have to be reviewed by the Attorney General of Massachusetts before they become effective in your city or town. Regulatory powers, you all know this, those who are on commissions anyway, you generally can review and approve of all exterior changes visible from a public way. and you need an HDC approval on those things to get a building permit. Now, I'm remembering, just as I'm saying this, that 40C explicitly excludes color, paint color. In Lexington, we still have paint color because we preceded all of this. But it's okay, it works. And then who appoints you? City Council, Select Board, Town Manager appoints the members. Historical commissions get their authority from Chapter 40, Section 8D. And again, a very broad statement of what they can do. Preservation, protection, and development of historical or archaeological assets of a city or town. That's not much design oversight, however. Many towns have demolition delay authority vested in the commissions. Many commissions can develop, well, most commissions can develop inventories of historic properties. They can hold preservation restrictions. They can provide programs, but they can't tell you what color to paint your house. And again, they're appointed by the same group that appoints the historic districts commissions. Some historical commissions, as Michael noted, are combined with their historic districts commissions. For example, in Brookline, I believe, they have a preservation commission. One size fits all. Neighborhood conservation district commissions, a rather new way of protecting individual neighborhoods, not townwide regulation, but local. There is no state enabling act for these things, so you have to do it through a bylaw or an ordinance, which requires not only local approval, but also the Attorney General approval. And once it is approved, there is review and approval of substantial changes to properties in the district. We call it Historic District Commission Light, because you only look at demolitions and construction and new additions and exterior changes that substantially affect the significance or cohesiveness of the NCD. We don't control, neighborhood conservation districts don't control what doorknobs or lighting you use on your property. And again, they're appointed locally by the City Council, Select Board, Town Manager. Other local preservation organizations that you may have encountered, basically they have no regulatory authority unless they specifically provide in their very limited constitutional documents how. For example, neighborhood design review boards. We have had several of these in Lexington, and we continue to have one in at least one neighborhood. These are where the neighbors get together and decide that they want to control what's going on in their neighborhood, and it's not controlled by anybody else, for example, a historic district commission. So these can come about either by contract between all the neighbors, or originally, in some cases, by provision in the deed setting up the neighborhood, such as a couple of our mid-century modern neighborhoods. The language was actually in the deed, but those deed restrictions expire after 30 years under the Massachusetts statutes of limitation. So if they're in place, but you want to have them renewed, you got to go back to your neighbors and get the contracts re-signed. National Register districts have to be approved by the Massachusetts Historical Commission and then the National Park Service, and they have very limited regulatory authority. The only time that they are affected is when there is one of those Section 106 or state reviews because of state or national federal projects, which involves the consulting process that we were talking about before. But otherwise, most National Register districts coincide with local historic districts, and if they do, that's how they get their protections. Historical societies, forget it. Those guys are wonderful organizations in any city or town. They provide archives, they provide programming, they provide all kinds of archiving, all kinds of resources for preservation in those towns, but they don't regulate any of the properties that we've been talking about. Okay, what do you need to know as a commission member? Well, there's a couple laws that you just can't get around. And I'm not going to talk about them because you probably already know, because you probably have had confrontations with your town clerk about getting the certificate signed that you've passed, that you've received these things, and that in the case of the conflicts of laws, that you've sat through that 2-3 hour training session that tells you how to avoid conflicts. So I'm not really going to talk about them, but know that you need to know these, that these do apply to you as commission members, the open meeting laws and the conflict of interest laws. You also need to have a very good knowledge of Chapter 40C or your special act. Memorize this stuff, especially the procedural requirements for notice, for posting, for getting signatures on things. Because if you mess up, this provides an entree for an unhappy applicant to overrule what you just decided. I have experience in this. Lindsay knows this. We had an EMHCC case where the commission neglected to get a certificate of continuation signed. Well, the expiration passed and they said, okay, we're home free. And they were. I find it useful to keep a copy somewhere near you when you're in a meeting, because if there's any question, you can look it up. You also need to know your local adopting ordinances or bylaws, if they vary at all from 40C or the special act. You need to know your local regulations and rules. You need to know your local guidelines and policies. And there's a reason for this, because, well, I'll get to that in a minute, but they do provide a basis for acting consistently. Lexington has 27 guidelines just for alterations to buildings. If you have these guidelines, and if you are specific, and if you stick to them as a basis for your decisions, and you quote them as a basis for your decision, you're much more likely to have your decisions upheld. The standards that you can apply, well, again, I'm repeating, but your formally adopted local regulations, guidelines, and policies, the Secretary of Interior standards, National Register criteria, state and local case law precedents, as well as your own decision-making. These will ground your decisions so that you will stay out of trouble. If you apply the laws and regulations and guidelines and policies uniformly and consistently, you will avoid actual or perceived, and this is important, bias or arbitrary and capricious decisions. If you document and post your decisions, if you keep accurate and complete minutes of your meetings, if you recuse yourself, if there's an actual or perceived conflict of interest, if you stay within the limits of your authority, that is, don't go off on a tangent and start applying something that is not grounded in all of the bylaws, rules, regulations, and guidelines. Avoid ex parte communications. These are side conversations outside of the meeting that cannot influence your decision. Everything that you decide in your commission meetings must be based on what you heard in the open meeting presentation. And if you have any doubt about any of this stuff, call your town council. That's what they're there for. They want to keep you honest. They want to avoid town liability. And finally, if the laws, regulations, guidelines can't help you, that is, you've complied with them all, but you just can't get the results that you want, you need to go to the court of public opinion. If you build bridges ahead of a conflict so that you can call for help later by cultivating relationships with town officials and other boards and committees, especially planning and the building department, if you coordinate with other preservation committees and organizations, and if you look for opportunities to publicize all your good work, if you build good relationships and good PR, then when the regulations and laws fail you, you still may get what you want. Thank you.
Thank you, Marilyn. That was excellent. And thank you for everyone as you put your questions in the chat and everything.
Yeah.
Marilyn, you can stop sharing and
There it
we
is. Thank you.
will turn
Okay.
it over to Sarah.
Thanks, Lindsay. I'll get my presentation up. All right. Can you see that full screen?
Nope, it is still, yes, now it is full screen.
Okay, a bit of a lag. Thanks. Hi, everyone. As Lindsay mentioned, my name is Sarah Scott, and I am her colleague here at MAPC. I'm a senior regional land use and historic preservation planner. And I'm going to just share a few slides today to follow on what Michael and Marilyn have shared to talk about kind of what it means to make decisions in the context of your local community's plans and values and goals and vision. A lot of the work that I do here at MAPC involves working with communities on long-range planning, whether that's master plans, historic preservation plans, or doing zoning projects. And so a lot of the conversations that we have are really trying to help communities understand what is that long-term big picture that they want to move towards, and then how can we provide specific recommendations to help them implement that vision and be able to achieve those goals. So I just wanted to talk a little bit about how that relates to some of the nitty-gritty that Michael and Marilyn were talking about earlier. So just to reiterate, as I think both of them had talked about, your role for those of you who are on a local board or commission is really to serve your community. And every community in Massachusetts and really everywhere has a unique context and a unique set of values and goals. So Lexington is not the same as Watertown, is not the same as Quincy. And that's great. And there's a lot of flexibility in the ways that local governments function that allow you to be able to state those values and goals and act on them. So your role as a local board or commission member is really to make decisions that align with your community's context and values based on your best judgment. So really, it's important to understand not only what your perspective is, but how are you representing your community and what your community wants. I thought it might be helpful to do a case study walkthrough to just show a little bit about how different communities might make different decisions about a similar case study, just to show what I mean by understanding those unique context and values. So I just came up with a fake scenario. This is not based on anything real. That a historic district homeowner, this home here that I found on Google Maps, wants to convert a purpose-built single-family house, so a house that was built to just house one housing unit, into a primary dwelling for themselves, as well as an accessory dwelling for their adult child. So it would be essentially an internal EDU is what we would call it. There wouldn't be any external additions to the building. In order to do that, though, they propose a few things. One is adding an entrance to that new second unit on the first story, where you can see the number 1 kind of under that portico. And they'd create an opening in the building exterior where there isn't one currently and wasn't one originally, hasn't been one historically. Another proposed change is to add a window on the second story, where you can see kind of right above that same pediment, in order to make the living space better for that second unit. And then they also are proposing to install a fence around the perimeter of the property because the adult child of the original homeowner has a dog and they want the dog to be able to go out in the yard without a leash. So how would you make this decision based on your community's context? In community A, there are a few considerations in terms of what that context is. They have recently adopted a housing production plan that recommends converting some of these historic single-family houses into two-family houses in order to better meet the housing needs and the population of that community. So this is something we see often where, for example, you have a community that is aging and you have smaller household sizes, and you might have houses with 3 or more bedrooms, but really the people living in them only need 1 or 2 bedrooms. The community also recently amended its zoning bylaw at town meeting, an overwhelming approval at town meeting, to allow this single family to two family conversion in the zoning district in mention. And the local historic district has design guidelines that allow historically appropriate fencing styles in a variety of materials. So if you are a local historic district commission member in this community being asked to make a decision about a certificate of appropriateness like this situation, here's how you might make a decision. You may allow the door to be added to go to that second unit, as long as it matches the size of the existing historic door frame, but also making sure that it's clearly distinguished, not to look like false history. So that's following the guidelines in your community. You would probably allow the window to be added, but you would ask the applicant to match the size of the single window on the second story of a secondary elevation so that it's roughly in keeping and you're not going to get a ginormous picture window or something like that. And then you might allow a composite material picket fence to be installed back of sidewalk. Again, this is not necessarily saying that these are the right decisions or the best decisions or exactly how this community should be deciding on this case, but just trying to give an example of how some of these other aspects of kind of community values and community goals might be translated into a decision by the local historic district commission on this case. So in comparison, there's another community, Community B, that has the exact same type of application, but their context is a little different. So in this community, they have a recent comprehensive plan that lists preserving historic buildings as one of its primary goals. They only allow single-family houses in this zoning district. And the local historic district has design guidelines that allow for historically appropriate fencing only in traditional materials. So this commission might make a different decision based on that context. They may not allow any new openings into the facade. They might work with the property owner and the architect to redesign the project using a less visible side or rear entrance rather than that front entrance. In this case, that same building actually does have this kind of side rear entrance here on a different elevation of the building. And so the commission might say, you know, hey, we know that it's going to require you to change the floor plan a little bit. You might not get the same dimensions of the living room that you wanted, or right, you know, those sorts of things. But it's really important for us to maintain this character of it looking like a single family house. Even though you are legally allowed to have an accessory dwelling unit in this structure, we're going to ask you to try to maintain the character of this neighborhood by working with us to have this kind of secondary entrance. And then the commission might allow a wood picket fence to be installed back of sidewalk based on some historic photos of the property that were found. So again, not necessarily the better or the worse or the right decisions, just trying to provide an example of how context might influence some decision making. And I'll just leave with a few other words of thought. One of the things that we have seen in some of the work that we've done is a real kind of schism between the kind of local historic district commissions or local historical commissions and a lot of the decisions that are being made at the municipal level, especially around new development. And so one thing that I think is really important is to just find ways to be part of the conversation. And I know that many of you do that. Sometimes you can ask to have a seat at the table, and sometimes you just kind of have to show up and pull the seat up yourself. but really try to look for opportunities for your board or commission to be involved in community conversations. Honestly, same goes for municipal staff. Really trying to build relationships and try to understand who in your community is responsible for driving some of this work forward and making some of these decisions that would impact the commission. We'd also recommend regularly reviewing and, if needed, revising your decision-making frameworks to align with community goals. So Marilyn had a fantastic slide showing the differences between bylaws, regulations, rules, and guidelines. If your community has done a big update, for example, your comprehensive plan, or you've recently amended your downtown district zoning, as a commission, take a look at that set of documents and try to understand, okay, where are we still in alignment? Where might we need to make some changes in order to be able to carry out those goals? And then really just be a resource, like Marilyn said, try to be helpful and provide opportunities for education. I also put on the side here some routine planning processes that communities regularly do that it would be helpful to keep an eye out for, and to try to be a part of these processes, whether in formal or informal ways. A lot of communities will do comprehensive or master plans, usually about every 10 years or so. Communities also have to do open space and recreation plans in order to be eligible for funding from the state. And I believe that that's about every 7 years. Housing production plans, similarly, that's a requirement for many communities, especially those that don't have affordable housing above the subsidized housing inventory threshold of 10%. Hazard mitigation plans also have historically been required by FEMA to receive funding. And then many communities will revise their zoning bylaws, if not regularly, then certainly with some amount of regularity. So just wanted to share a few of these just to provide some examples of what that context might look like. And Lindsay, I think I will turn it over to you.
Perfect. Thank you.
Do you want me to advance your slides?
Nope, you can unshare it and I will share it. Let me do this. Okay, can everyone see that now? Oh, hold on. Helps if I don't pull Michael. Sorry, Michael. I did the same thing. I didn't push the share button. It's just so excited. Sarah, does this look good for you guys? Okay. So now I'm going to talk about a project that I led with the town of Marblehead to offer updates to their guidelines for clean energy retrofits in the old and historic districts. So first, some background about Marblehead and their push for clean energy. The community in 2018 adopted Article 45 at town meeting, which was to support the town's goal of achieving 100% carbon-free energy by 2040. And given that so much of the community is covered by the old and historic district, the town looked for help in how to navigate the two goals of preservation and clean energy. Marblehead initially reached out to EMHCC about their project idea, and EMHCC put them in contact with us, MAPC, as we have both a historic preservation practice area and a clean energy department. And so we had the in-house expertise to run the type of project that they were looking for. MAPC awarded the town some of our TAP funding, which I will speak about later when we get to conversations about funding. Our charge was to work with the town to offer a proposed guideline revision text that would better balance historic preservation with 4 clean energy retrofits that the community was most asking for, which were solar, heat pumps or mini splits, electric vehicle charging, and also windows. And this was around the time of the passage of the state climate bill, which had very specific requirements for solar and electric vehicle charging for historic districts, some just for 40C, some for both 40C and Special Act districts. So the MAPC team began by reviewing the Secretary of the Interior's standards for rehabilitation with a focus on the sustainability guidelines for rehabilitating historic buildings. We also reviewed the Advisory Council on Historic Preservation's policy statement on climate change. and we paid particular attention to the section that states public serving institutions should contribute to decarbonization by promoting reuse of older and historic buildings and by encouraging the thoughtful retrofit of such buildings to improve operational energy efficiency. And so together, these federal references sort of anchor preservation practices nationwide and help ensure that local criteria are predictable, defensible, and easy to share with our communities. And from there, our project team identified 3 guiding principles that aligned with the National Historic Preservation best practices and would ground our project at every step of the way. And so they are, the first one is reversibility. And so this means that any upgrades would need to be able to be removed later without damaging the historic fabric. And so while you could actually remove a few slate shingles to install solar panels on a roof, you could not remove a dormer to install a solar panel. The next one was distinguishability. And so that means that any new clean energy retrofit should be compatible, yet clearly contemporary. You want to avoid a false sense of history. And so you could install flush black solar panels on a secondary roof plane or place a mini split condenser at the rear with a simple sort of modern screen or fence, but you cannot use fake architectural elements to conceal equipment. For scale, this means that additions remain proportionate so that the historic building stays the visual focus. So again, for solar panels, you don't want them to overhang the roof, but for heat pumps, they should not be oversized, stacked on platforms, or placed where it dominates primary facade. And so when we use those, it is important that these principles demonstrate that new interventions, including these clean energy retrofits, can actually strengthen rather than weaken preservation when grounded in accepted professional standards. So from there, we actually created a matrix that reviewed the current Marblehead Historic District guidelines around the 4 that we are looking at, alongside federal guidelines, and the peer communities of Nantucket, Concord, and Salem. We also checked the guidelines to see where they supported the town's climate commitments and where they did not. And this helped ensure that the proposed recommendations that we would later craft aligned with both preservation norms and modern climate needs. And I will say, since I have been asked why we didn't go with the sort of standard red, green, orange, yellow sort of colors for the matrix, we actually picked colors and dashed lines to help distinguish them better for people with visual disabilities, such as color blindness. Our final product was a draft of the proposed recommendations for language change related to, again, solar siting, heat pump locations, electric vehicle charging, and windows. And each section expressed our 3 principles of reversibility, distinguishability, and scale as approval criteria that the applicants can meet. And we developed the language for the proposed revisions through meetings, tours, expert input, and I'll speak to those steps now. So for the collaboration aspect of the development for the proposed recommendation language, we held a joint session between the Old and Historic Districts Commission, which oversees the Old and Historic Districts, and the Green Marblehead Implementation Committee, which is charged with work focused on reducing the town's carbon footprint so that they could meet and share their priorities and perspectives on both clean energy retrofits and historic preservation. We also held a community charrette with residents and local stakeholders, and we invited 2 experts in historic preservation and clean energy to participate. The experts were Margaret Back, Preservation Projects Manager at Newport Restoration Foundation down in Rhode Island, and Elizabeth Paliga, Preservation Services Manager for Northern New England at Historic New England. We also went out into the field with over 25 interested residents and town staff to look at properties in Marblehead and 12 properties in Marblehead and 10 properties in Salem. And this provided us with a comparative experience showcasing both positive and negative examples of clean energy retrofits integrated into historic homes. We also shared the draft of the proposed recommendations with historic preservation experts from the city of Salem and again, Newport Restoration Foundation, along with both the Olden Historic District Commission and the Green Marblehead Implementation Committee and Marblehead Town staff for feedback and comments. From there, we finalized the draft language for the proposed recommendations, which we just delivered to the town in August. And together, this input and work produced for us a clearer, more usable language aligned with the Secretary of the Interior and the Advisory Council on Historic Preservation, reducing conflict through predictable guidelines and with the intention of giving residents confidence that well-designed upgrades can and will be approved. So now how can your community adapt this approach, whether it's for clean energy, retrofits, ADUs, or anything else that you might be doing? First is to start by looking at the Secretary of the Interior standards so that your decision and revisions follow national best practices. Then create your own comparative matrix to test your local rules against national standards from the Secretary of the Interior and the Advisory Council on Historic Preservation. And be honest when doing that. If your current guidelines are out of step with the federal guidelines, but equally be honest and give yourself kudos when your guidance exceeds the federal standards. That actually happened with Marblehead for windows around non-invasive techniques such as using curtains and landscaping to help make windows retain better heat. And I know Nantucket has that too. So. And we will be sharing a template for the clean energy self-assessment matrix along with the recording and the follow-up email. So you can take that and do your own or sort of see how to do it if you want to do it for ADUs or other things. And then when you go to write your updated guidelines, you should start from a place that allows clean energy retrofits or allows whatever you are looking for, provided that they are placed, sized, and discreetly screened to protect significant features so that the compatibility comes from good design, right? And finally, you shared observation, whether through site visits or photos, and share drafts with external experts and local boards to ground the work in community values. And again, those preservation best practices. As Michael noted, historic districts aren't meant to stop change, but ensure that it is thoughtful and appropriate. And as Sarah made clear, it's important to use your charge and power as commissioners to help uplift the priorities identified by your particular community. And again, finally, as Marilyn noted, act in a way that creates good working relationships with other boards, municipal staff, and the residents that you serve. So I hope that our work has not only shown that historic preservation and climate action can advance together, but that our process can be applied to all types of reviews by historic district for historic district guidelines, not just clean energy retrofits that we were looking at. And again, remember to treat climate action and equally efforts on housing or other community priorities as a form of care and love for the places and ideals your community values. Use historic preservation as a practical tool to advance those goals and aligning projects with shared values while protecting significant features and histories in your landscape. So thank you. I will stop share and then we will briefly talk about funding. Which is everyone's favorite topic. I will start first, and then Michael, I didn't know if you wanted to come off video or come on video and share a little bit about survey and planning grants and anything else that MHC might have available. I know there are some changes for this year. So for MAPC, if my colleague Sarah wouldn't mind putting in a link to our TAP landing page. So TAP is MAPC's technical assistant program. And this funds MAPC staff time to support municipalities with technical assistance work. It does not provide cash grants for you to take the money and go work with someone else or do it internally on your own. But again, this is the type of funding that Marblehead received for their project. The applicant must be a municipality within the MAPC region. So you have to be one of our 101 communities. And it has to come from the town. So it would either come from like the town manager or sort of the mayor, often another staff member or a planning department will put it forth, but you need the sign off typically of whoever is leading your community. TAP does not require a grant match from applicants, but it can increase your overall competitiveness if additional funds can be contributed to a project. Also, sometimes TAP funds can be used to augment another project you might have already gotten a grant fund for. So I will say the town of Stoneham received some grant funding for their historic preservation plan that we worked on, but they had already received also a survey and planning grant from EMHCC. So they were able to sort of tap into both funds by applying for that. And then while TAP accepts project concepts on a sort of rolling basis, so anytime throughout the year you can do it. If you apply by Monday, December 8th, 2025, your project will be considered when we have the greatest amount of funding available. But if you can't meet that deadline, that's just sort of a soft deadline. You can, apply in January, February, and you can also talk to MAPC staff at any point about a project idea so that we can help you sort of hone in on what is most likely to get funded by us and just to make the project application stronger and everything. So with that, I will turn it to Michael if you want to talk about survey and planning grants and other things.
Unmute myself. The Massachusetts Historical Commission's Survey and Planning Grant Program is a federally funded, reimbursable matching grant program to support historic preservation activities in communities throughout the state. Let me just turn that off. It supports completion of historic properties inventories, nomination of significant properties in the National Register, completion of community-wide preservation plans, development of other sorts of reports, including design guidelines, publications, and other projects related to the identification and protection of historic properties. In most years, eligible applicants are all local historical commissions, historic district commissions, planning offices, and other eligible public and nonprofit historic preservation organizations. If you pay attention to the news, you know that federal funding is questionable at this point for many of us. And for fiscal year 2026, at this point, our federal funding is extremely uncertain. And with that in mind, we are only going to open the FY26 Survey and Planning Grant Program to the 31 communities that participate in the certified local government program in Massachusetts. We are required to pass through 10% of our annual federal funding to certified local governments. So anticipating that there will be some level of federal funding for us in FY26, we are going to proceed with that program. So pre-applications and announcements have been sent out to the local government program coordinator, the certified local government program coordinator in those communities. If you're in one of those communities, pre-applications are due November 19th. Invitations for full applications will be made at our December commission meeting. Full applications then will be due in February and voted on at the March MHC meeting. Again, just due to continuing uncertainty for federal funding, that we anticipate that we'll have a reduced program if we're able to have a program at all for FY26. So there's glass half full there perhaps, and we're hopeful going forward that at some point our federal funding will get back to normal situation. So that's basically it on the MHCN.
Okay, well, thank you for that update, Michael. So now we're going to turn to questions. I know some people have been putting some questions into the chat. We'll start with some of those, but if you have questions, put it in and we'll sort of popcorn it around to the different experts who can answer stuff. I will say, I will start with one that I can sort of vaguely answer. You might not like my exact answer, but from Barnstable is wanting to ask about the new stretch code and its impact on buildings 75 years of age or older that are not yet inventoried, listed, or contributing to a NR district. So as you may know, there are some exemptions in the stretch code related to historic buildings, but they have to be either on the National Register or sort of the state register. So I can connect you with our clean energy department to answer this more in depth, or also reach out Barnstable to Sarah Korjeff, who's at the Cape Cod Commission. She's their historic preservation planner. But basically, if it's not inventoried, I don't believe you can get an exemption. And this just goes to the importance of inventorying your buildings and continually updating MACRIS and submitting those to MHC. I know my town is doing inventory survey master plan and everything so that we can be very thoughtful about doing this. Because if it's not inventoried in planning and then a lot of the stuff, it unfortunately doesn't exist, no matter how important it is to your community. If you want to email me, I was going to say that has to be very new that Sarah Korjeff just retired from the Cape Cod Commission, because we were just talking to her just a few weeks ago. So she will be greatly missed. So Bob, if Sarah can put my email in the chat, if you want to reach out to me, I can talk with you in our clean energy department about this in more detail. Then we have a question for Marilyn. Does posting of minutes suffice for your suggestion to post decisions?
I would say yes. Although both the commissions that I know of anyway send written notices to the applicant for them to act on. And those notices, as coming from a town body, become public records. So they are on record if anyone wants to look at the card for a given property. It will indicate that a decision has been made, and I think they post a decision as well, or if it's not posted, there's a way to get to it. So the answer is yes. I don't think you need to have a separate posting that for your decisions, but it's there if you want to see it.
And I'll just add too, when you do a decision, you don't have to like pages and pages, but you do need to sort of explain the decision again in terms of, you can't just be like, we denied the certificate of appropriateness, because as someone who helps run our appeals process, and Marilyn, who sits on the appeals sort of panel that we run, we need to know what someone is appealing, and we need to know why you made the decision, sort of in what decision it was. So you do have to put some information into that. Otherwise, it can be very hard.
If I could add to that, your minutes don't have to describe everything that was said by every person. But if you can provide your justification for the decision, you're not going to remember this next month. So if you have it on record of what was said and what was the basis of your decision, then that is going to protect you against challenges down the line.
Yes. So we have another question that I'll answer from Anne, and that was that I said some of the state laws apply to both 40C and special act, and others apply only to 40C. Do I have that information handy? So yes, for the climate bill, and I say this because Marblehead is a special act. And so in the climate bill, the solar energy siting was related only to 40C. Whereas the electric vehicle portion of the bill applied to any 40C special act or otherwise created local historic district or other sort of historic regulatory thing. So like in Ipswich, the APDC would fall under that, just for the electric vehicle charging, but not for the solar siting, I mean. Question for Sarah. Is there any guidance to help to prevent demolition by neglect?
Well, I put in the chat my master's thesis, shameless plug, which was about the use of eminent domain, actually, to deal with preservation or to deal with demolition by neglect, and talks a little bit about other strategies for combating demolition by neglect. I will say that's probably the extent of my knowledge on that issue. So if Marilyn or Michael have other thoughts, I'd be interested in hearing them.
Well, we have demolition by neglect in both our historical commission demo delay bylaw, and there is a reference to the HCC in it. So both commissions are covered. And if memory serves, and I hope it does, it's not eminent domain, but it's a matter of if certain conditions exist, then the commission can ask the building department to step in and do a survey to see if they agree that those conditions exist. And if they do exist, can put liens on the property until the conditions have lifted. Or if they feel that the conditions don't exist, then the whole issue goes away. But yes, you can definitely do this. We have this, and I know that Brookline has it because Lexington shamelessly copied Brookline's statute when we put ours in place. And we've actually used it a couple times. But again, the building department doesn't have quite the same appreciation of some of the finer points of historic preservation that the Historical Commission or the Historic Districts Commission have, but we get along.
Thank you. Then there was a question, Michael. So does the MHC have any advice as to the role of local historical commissions in reviewing Community Preservation Act historic preservation projects in the review process before recommending to town meeting?
So I guess there are two areas where the local historical commission might have input. One is if the property isn't listed in the state register, state or national registers, then the historical commission would need to affirm that it's a historically significant property and qualifies for CPA funds. The second, if the commission is involved then in reviewing, I mean, there's a commission member on the CPC presumably, in reviewing the project, any historic preservation project needs to meet the Secretary of Interior standards for rehabilitation. So the commission, that is the commission's role to pipe up and assert whether or not that project appears to meet the standards. So those would be the two main roles for the commission.
Thank you.
Lindsay, if I could just add one
Yeah,
other thing.
please.
And I say this as because of my role on our town's Community Preservation Commission. If it's a historic preservation project, but it's not coming from the Historical Commission or the Historic Districts Commission as project proponent, then it is helpful to have the other two commissions or the relevant commission weigh in on the application with a letter of support, because that letter gets posted along with all of the other documentation for the projects when we go to town meeting. Every project has whatever has been presented in support or against the project for the town meeting members to understand what has gone into our decision-making process.
Right, and certainly if it's a project in a local district, you want to make sure the CPC is funding a project that would pass muster with the district commission.
we ask for that first. We
Yes.
want to make sure that the
Right.
EHCC has approved a particular
Right.
project before they even come to us.
Another question is for Sarah. What are a couple examples of false history?
So by false history, I was talking a little bit about what you had mentioned in your presentation, Lindsay, about around distinguishability. So this is a standard that's cited in the Secretary of the Interior standards, which basically is meant to say that any kind of changes to a historic structure, whether it's new construction, alteration, addition, is not meant to make it seem like it is also the historic structure, that there's some amount of distinction between what is new, what is a change, versus what is the original historic structure. So it's certainly a fine balance between having something that is within the context of the historic structure, but distinguishable, versus something that is kind of wildly out of context. And I think that that's where training and experience and working through some case studies and examples can be really helpful for local commissioners.
Another question, this one's for Marilyn. Are there recommendations for guiding historic district commissioners who are reluctant to adopt regulations where they have a strong preference for taking every project on a case-by-case basis?
Say that again. I'm sorry. There were too many depending clauses in there.
So do you have any recommendations for commissioners who are reluctant to adopt sort of standard regulations because they have a strong preference for reviewing every project on a case-by-case basis?
I think it's dangerous. If you review on a case-by-case basis, then all of your decisions are kind of ad hoc. That is, they have no, they're not grounded in the decision-making process that the commission has been engaged in over the years. And I think that then that they're much more likely to be open to challenge. Well, you said that this project could go through on this basis, or this house could have this. Now I want it too. You don't have, if that first decision had said you can have this because our guidelines say that it's an appropriate change, then the next guy that comes before you can rely on that. But on the other hand, if in the first decision you said it does not comply with our guidelines, then that's also compelling. Well, it's a compelling reason to refuse it the second time.
Yeah.
I don't think that you should be making decisions on a case-by-case basis. You have to make the decision, but and if there are specific factors, like the difference between Sarah's case A and case B, if there's specific factors to take into consideration, that's legitimate. But for most of the decisions are kind of based in the same issues.
Mhm.
And I would hold to a guideline for or a regulation for that, rather than doing it, well, let's see what we think about this today.
The other thing I would add is, again, as someone who helps administer the appeal process, is you need to have this stuff written down so that, again, the residents can see it, even if your commissioners know these are like the sort of guidelines and rules in how you judge a project. You have to write it down for the residents, for any applicants, because otherwise, as Marilyn said, it's not defensible. It would be seen by the courts as arbitrary and capricious potentially, right? Like it opens up that, and that's how in our appeal process, as long as it's not considered arbitrary and capricious, the decisions are upheld, for the we uphold the commission's decisions. But so you don't want to enter any uncertainty into that and everything. So writing it down so everyone knows and it's documented only protects yourself and everything. Another question is, let's see. So I'm just going through our things. Michael, we have a question from Medford. They wonder if the National Park Standards, the Secretary of the Interior standards were ever to be repealed at the federal level, would the Commonwealth step in and set up their own sort of state level standards?
Well, can't really answer that hypothetical question. Sorry. I think if they were repealed, then the document and the history of the standards would still exist regardless. And I think in the absence of them being codified, I mean, they are still widely, I mean, the use, for example, by local historical commissions of the Secretary of Standards is not under any federal codification, but more of the fact that these are nationally recognized standards that are widely applicable. So even if they were for some reason repealed, they would still exist, and I mean there would be no reason to reinvent them. So I think in that instance, I think people would still be using them.
Thank you. So we'll turn to sort of find one last question. And actually, I will turn it to Marilyn for this last question. It is a bit of a long one, Marilyn, so please bear with me. And I can repeat whatever you need. So we have a commission, as a commission chair, this person has the authority to make preliminary determinations around, like, say, applications for partial or full demolitions under their demolition delay ordinance. To avoid errors, they would like to consult with their vice chair in making these determinations. Should we decide that a public hearing will be required, has our communication been a violation of the ex parte rule? Would, they say they would be careful never to consult with more than one commissioner in order to avoid violation of the open meeting law.
I don't think it would be a violation, if I'm understanding the question correctly, if all of the reasons for, if all of the evidence that was presented privately, and I'll use the word privately, meaning just to the two of them, if all that evidence is presented again to the commission on a new, it's de novo, another legal term, a new basis, that is, everyone hears the same thing that the two heard, and if the commission decides as a commission that based on the facts and information presented, it should proceed one way or the other, then no, I don't think it's a violation at all. But I'm not giving legal advice.
Yes, again, none of this is legal advice. We're just trying to help everyone and, sort of, think through this all together. With that, we will do one little last poll, just about, it's not coming up for me yet. It's a blank screen, Sarah. I don't know if anyone else can see it, because we just would like, or if you put in the chat sort of.
You can't see the poll at all?
I cannot. I see a thing that popped up, but there's no text or bubbles or anything.
It looks like folks are responding to it.
So maybe it's just
on the same Zoom line.
Oh, maybe. Because this has seemed like, this is something that has shown up again in many of our projects, in conversations with people. And so we're just curious again, what is sort of most impacting your community. And again, as I know some of the questions relate, like, who can I talk to? We're doing bylaw revisions, or I have this question. I'm not saying Sarah, myself, or Michael have all the answers, but again, please reach out to us. You can find me and Sarah on the MAPC website. Our contact information will also be in the follow-up email. Please reach out to us, If you're not in our region, you can still reach out to us. We may end up turning you back to your regional planning agency for connecting you with them for more direct help, because they will better understand your community than us, but we are happy to talk with anyone and everyone.
So I will just say, it looks like a lot of folks said that there's friction with zoning. And as a zoning planner, who is also a historic preservation planner, I'd be very interested in learning more about what some of those points of friction are, and if there are opportunities, perhaps through a TAP project, like Lindsay mentioned, for MAPC to work with any of your cities and towns on trying to resolve some of those frictions.
So with that, thank you everyone for a great session. I hope this was helpful to all of you. I know it was helpful to all of us to think through our different projects and what we were presenting and everything. So have a wonderful Tuesday and go get some lunch. Bye.
Thanks, everyone.